In this video, we're going to be covering, as you can see by the title, special education law. Now, there are 3 laws. All of them are federal laws. They cover all 50 states in America. So they're applicable to every school district, every state in the union. So they are of 3 varieties in terms of providing rights and benefits to persons with disabilities. The first one is the Rehabilitation Act of 1973. Now, there were 2 significant acts that had to occur prior to this. One is the Civil Rights Act of 1964, which, as we know, covers individuals of color, ethnicity, and things of that nature, and provided rights for them. That law is still active, still in place, policed by the Civil Rights Division of the federal government. And following the Civil Rights Act of 1964 was the Title IX, which is 1972, which gave rights to women for access to entrance into medical school, law school, engineering school, greater access in all those 3 areas, as well as had a major impact on providing athletic programs for ladies in consistent with what's available for men. So that was the Title IX Act, which occurred in 1972. Well, in 1973, finally, now we're going to be thinking about persons with disabilities. And this covers 4 basic areas. One, it forbids discrimination to anyone with a disability. Now, this is children, adolescents, and adults. So this is applicable to all age groups. Number 2, it created handicapped parking, which I notice is misspelled. That's okay. Handicap. That's the only time we can use that word, because that word pretty much left the language of disabilities in 1990. So we don't use the word handicapped or handicap in reference to any of those disability populations. So, but that gave access to close proximity parking for persons with disabilities. The third part of this, which was only the beginning stages of accessibility for people with disabilities. It did not provide any type of specificity as to, detail as to those accessibility features, but it did provide the beginnings, and it was accessibility for persons to buildings that may have purchased out of tax dollars. So it was really only for the tax dollar built facilities, schools, government offices, and things of that nature. It did not include, your Walmarts and your McDonald's and things of that nature that came later. But it did provide information on elevators, ramps, curb cuts, and things of that nature. So again, only the beginnings, but at least it began to open doors of accessibility for those with physical disabilities. The 4th part of the Rehab Act is Section 504 plans, and these are plans written to assist people with disabilities. They're very simple to construct. They do not require extensive proof of disability. They do not require extensive evaluations or diagnostic procedures. They can be written on one piece of paper. Only 3 people need to be in attendance to write a Section 504 plan, and that is an administrator, a service provider of any type. It could be a teacher, it could be a social worker, it could be a speech pathologist, it could be a school social worker. I've already said that, or a school psychologist. and then of course the parent. So three people are all that's involved in there. And it's to help students who struggle in some specific area with some type of relief that's going to make them more successful in the educational setting. So there's no money attached to anything here in the Rehabilitation Act. There's no reimbursement to school districts of any kind, but it did provide us some really interesting beginnings. And the Rehab Act is definitely still in force. It is policed by the Civil Rights Office of the federal government. And so if someone feels as though their rights are being abridged in any way, they can file a complaint with the Office of Civil Rights. And the closest office around here is in Chicago. Next slide. The most important piece of legislation that opened doors of education, specifically public education for students with disabilities, was the Individuals with Disabilities Education Act of 1975, abbreviated, and you'll hear it most frequently as IDEA. The first part of this law says that all students with a disability are entitled to a free, appropriate public education, acronym FAP. And parents do not have to pay for this education. It must be appropriate, and appropriate was defined by the court, which, because people said, well, what is an appropriate public education? Well, the definition is it must result in gains for the student, educational gains for the student. So the student must be in a learning environment where we are working on improving their skills in one and most often in more ways. So it has to do with results. It's results driven, that there's some educational benefit to the child, and that's the ruling from the court on what is an appropriate education. It does change the rules of suspension and expulsion. Suspension is limited to a maximum of 10 days per school year. That's an accumulated total. You cannot exceed 10 days. Anything in excess of 10 days would be viewed as a unilateral activity that denied the student FAPE. So 10 days is our limit. So we have to use them very carefully if we're involved in suspending any students who have FAPE. Expulsion, to the surprise of many, is not allowed. You cannot expel a student, no matter what the offense is, from their right to a free, appropriate public education. We typically, get the question, well, what happens if a student, pulls a firearm, or what happens if a student brings a gun to school, or what happens if the student is involved in selling drugs in the school property, so forth. Well, since we can't expel them, what we do is that we change their placement. They need something that's more restrictive, more structure in that environment, so we can really attend to their educational needs. Number two is the IEP. The Individualized Educational Programs came about as a result of IDEA. And these are programs that are tailor-made, written specifically for that student. No two IEPs should ever look alike. Since students are different, their educational needs are different, therefore their IEPs are different. And they cover a whole host of things which you can review on the video entitled Individualized Educational Programs. So I refer you to that video for more detail on IEPs. Under IDEA, the range of services is for students who are chronologically 3 years of age, so meaning that by their third birthday, they have the right to be in an early childhood special education program or some other service to meet their needs as defined in the IEP, and that we will serve them up to the age of their 22nd birthday. Now, not every student's going to stay till their 22nd birthday. Some are going to graduate with their class at the age of 18. There have to be specific educational needs defined by goals and objectives that still need to be met for them to remain in school beyond their senior year in high school. IDE rights end, they terminate when that student is handed a high school diploma or when they reach their 22nd birthday. We have no responsibilities under IDEA when either one of those two things occur. So it's really important for parents to be aware of it. There are students that we have allowed to go through the commencement activities like any other child, and but we don't give them their diploma. We've given them the cover to their diploma so they can continue their education until their 22nd birthday. But for many students, it's very appropriate they be given the distinction and the honor of attending a regular high school commencement. Number 4, least restrictive environment. Very simply stated, I've got it down to one sentence. What is LRE? Sometimes referred to as inclusion or mainstreaming in regular general education environments or classrooms. LRE is really to maximum extent appropriate. There's that word appropriate again. To the maximum extent appropriate, students with disabilities are to be educated with non-disabled, age-appropriate peers. Now that's period. That's individually determined by the IEP team. They take a look at it, and when they're talking about placement, they must discuss LRE. They must discuss to what extent is it appropriate for this student to be included in activities or classrooms with their non-disabled peers. Number 5, zero reject. Simply that. Any child with a disability between the ages of 3 and 22 must be served by the public school. Now, that doesn't mean they have to be served in public school. They can be educated and served in a private sector school, but the public school pays the tuition, the educational tuition for that child. So we can never say no to a child, no matter how low functioning they be, no matter how severe the impact of the disability may have on their lives. We cannot say no. We cannot turn them away. We must provide a program for them in that age range that I mentioned. And lastly, due process rights. In a perfect world, both parents and the school district would agree on everything, but absent that, school districts and parents both have due process rights. School districts have at times had to exercise their due process rights by going to a hearing, which is chaired by a trained hearing officer from the Illinois State Board of Education. All due process hearings have a court recorder where every word that's spoken is recorded, and it's a quasi-judicial proceeding with the hearing officer in charge. Typically, the school district is represented by an attorney, and typically the family is also represented by an attorney. And there is testimony provided, examination and cross-examination. It's a very adversarial proceeding. Both parties want to win. They want to get support in the hearing officer's decision for what they think is appropriate for the student. We as public school personnel are advocates for the student. We may be advocating for something different than what the parents want, but nonetheless, I think it's important for parents to know that we are advocating for what we think is, again, appropriate for that student. So the downside for the district, if they lose the hearing, if the hearing officer rules in favor of the parents, then the school district is responsible for paying the families legal fees. And that can be quite expensive. You could be looking at $50,000, $80,000, $100,000 to pay the family's attorney's fees. So you don't want to lose. You want to make sure that you have complied with all of the student and family rights as you proceed through your programming efforts for that student. So, excuse me, one of the major areas that seems to be the most contested at one time, about 80% of all due process hearings had to do with placement. Where are you going to serve this youngster? Where are you going to meet their educational needs, and what environment is appropriate for them, and so forth. So that's a pretty big decision that the school district makes. Okay, going on to the next slide. The final law is the Americans with Disabilities Act, ADA. And two broad areas are covered in ADA that affects persons with disabilities. One has to do with accommodations. Now, I need to dichotomize between a modification and an accommodation. People get this confused very frequently. They use them interchangeably, but modifications are driven by the IEP. You can modify anything in an IEP for the student. You can modify the curriculum, the homework assignments, your evaluative and testing measures. As long as you write it in the IEP, that modification must be made available to the student. Accommodations are different because they are not for the public school persons. They can occur in two environments. They can occur in the workplace. If you hire somebody with a disability, you need to make reasonable accommodations for that person to be successful in that workplace. And that could mean technology, could be a computer that talks to you or you talk to it if you can't manage a keyboard. So it can be a voice activated piece of technology. It can be, and again, we don't have to go through a great detailed evaluation to determine if the person has a disability. We look for some records, we look for some, usually from the public schools, to indicate that the individual, who is by now an adult, it does in fact have a disability. But it does include some other things that are not included in IDA. For example, obesity can be viewed as a disability under ADA, and we may need to make accommodations for them. So workplace, we want them to be successful there, and if accommodations are required, then we provide them. The other location is in higher education. Every college, every university has a department within its structure that takes into account persons with disabilities and will provide accommodations for them. That could be providing a wheelchair, could be providing a sign language interpreter for someone who's deaf. It could be giving them extra time to complete assignments, or extra time to take an examination, or to take an examination in a quiet, secluded place without distractions. Could even mean that we read the examination to them. But the fact is, accommodations do not allow for changes to the curriculum, to the testing, to the required assignments. All of that is the same. We may make some accommodations, but the work that's required is no different than it is for any other student. Okay, second part, and certainly a major part of ADA, is the architectural specifications. If you want to become an architect, you will take coursework on ADA architectural specifications. And that's in all places of business. Anything that is frequented by the public, whether it be private or governmental, must meet architectural specifications for accessibility. And now we're really getting serious, because no longer can you just say, well, that student needs a ramp. Well, that student needs a ramp that's at a certain level of incline, or that student needs a wider doorway. Well, it's got to be a specific, under ADA, we now know the specific width of doorways that are required. That large stall in the bathrooms, you know, from the wall-mounted grips, bars that they can grab a hold of, to the size of the space in that bathroom stall. All of that is very specific and must be complied with. It includes strobe lights for fire drills. I mean, just hearing the fire drill is insufficient. If you're deaf and you can't hear it, then there's a strobe light. We're talking about the height of water fountains, the height of whiteboards. We're talking about the width of curb cuts. It's just, major detail. Doorknobs are gone, and any kind of building remodeling or construction. We now have levers. Levers can be grasped a lot easier. If the person has a service animal that can open the door, it's much easier to do with a lever than it is to do with a round, slick doorknob. And so lots of detail here, and it's really great. Power doors. That's another part of the architectural specifications for facilities that really are helpful to persons with disabilities. So lots of coverage there, and thank goodness for that. Okay, I hope this helps. You can review this many times, and hopefully you'll be able to articulate the rights that are available to students. We must comply with these rights as a teacher, whether that student has a 504 plan, an IEP, physical disability, hearing loss. We must see that they are provided for thoroughly, competently under these laws. They're all in force today. Thank you.